All right. Good morning, everybody. For those that have jumped on with us, we have a special guest that's joining us this morning, Phil Trowbridge from the DES, the Land Resource Management Program Water Division. He's a manager down there from New Hampshire and knows all kinds of information that is pertaining to some changes that are happening to how site assessments are handled, who does them now, and all those types of things. And I've asked Phil to jump on and give us an overview, and will allow us to ask some questions of him. And as we all know, many of us have dealt with site assessment things over the years in our career, and now we have some changes, and it's they're serious. So I thought, who better to have come on than Phil? So Phil, why don't you take it away?
Hello, good morning, everyone. Glad to be here today. And as Ben has introduced, my name is Phil Trowbridge. I manage the Land Resources Management Program at New Hampshire DES. This is the program that deals with a lot of the regulatory programs. So we do wetlands permitting, shoreland permitting, subsurface permitting, which is septic systems, which is really what we're talking about today. And also alteration of terrain, which is the stormwater programs and requirements for large construction. So Ben asked me to come on board to talk about changes that'll be coming about for the waterfront site assessment as a result of a bill that was just recently signed into law. And this was a bill that I worked really closely with Bob Quinn from the New Hampshire Realtors Association to craft, and we came to agreement on how we could do this, and it was a good experience. I think both Bob and us realized that the way the waterfront site assessments were being done currently was not that effective. It wasn't achieving its goal, and it was also, I think, causing significant amount of resources to be spent by buyers and sellers, which is something we don't want to have. So my plan for today is I'm going to do kind of a quick overview of the big points, and then pause to see if anyone has any questions. And then I have a few details that I want to go over, and then we can do just other questions after that. So the big picture, the waterfront site assessments previously, the way it has been done up to now, has been that you would hire a permitted septic system designer to do the site assessment. And the goal of that, the purpose of doing that was basically to determine the lot loading of the site. Lot loading is basically how much sewage can be treated on a site, and it basically deals with what types of soils you have on the site and how big the site is. And this was put in place many years ago, and the point was because people were tearing down seasonal camps and putting in much bigger buildings, and then later saying, oh, I didn't know that I couldn't fit a 4-bedroom house on this site. If I had known that when I purchased the property, I would have negotiated differently or whatever, so it was to get that out in front. But the problem was, lot loading is just about the soils and the size of the site. It's not about whether the septic system is functioning properly. And as we all know, that's really an important thing, especially to protect our lakes and rivers, to make sure the systems are not in failure and that they're functioning properly. So there's a whole other evaluation that's done by a licensed septic system evaluator that looks at the actual septic system to determine if it's working properly. So that's the really big change here for that HB 1113, which is the bill, is bringing. So there's three big issues. First is that it changes the requirement of from hiring a septic system designer to hiring a licensed septic system evaluator to look at the actual septic system to see if it's in failure or working properly. Second big change is that we recognize that if the designers were still needed to be involved in certain cases, when either there's a system that does not have state approval, or the state approval was before 1989, which was before the rules got strict regarding the soils and lot loading. that we still needed a septic system designer to come out and look at the elevation of the septic system relative to the water table. Uh, you know, if the you can have circumstances where a septic system is apparently working, right? There's no breakout on the surface. People aren't complaining about it. But really, the problem is that it's in the water table, and that's polluting the groundwater of the neighbors and the lot, and it's also kind of leading to a straight shot into the water body that you're adjacent to. So we decided that it was smart to kind of switch the requirement initially to an evaluator for all sites, but then to keep the septic system designer involved when you have these older sites or sites that don't have any state approval. And then the third big thing is that there's going to be a requirement that if either the evaluator or the designer determines that the system is in failure, that the system needs to be replaced within 180 days of the date of the transfer of the property. So this is a case of, we want to be finding these systems that are in failure and making sure they're fixed as part of this real estate transaction. This is a big change. And one of the other things that the bill did was to add some flexibility, because we recognize sometimes things don't always go according to plan. So it does have an option for extensions of these timeframes for doing these evaluations or doing the replacement for up to 180 days more due to something that's outside the control of the buyer. And that's that can be something that's weather related. Some kind of work that's needing to be done in the middle of the winter, which would be better done when it's not frozen ground. We recognize that closing dates and things like that change for reasons outside of the control of the parties involved, and so those are other reasons that could for which an extension could be available. And then the last major point I'll make here is that, and at the request of the Realtors Association, was to put the responsibility for doing these evaluations and doing the replacements on the buyer, not the seller. The law previously had put the requirement to do the site assessment on the seller, and what we learned was that a lot of the buyers were also doing their own evaluations because they wanted to have that, they didn't trust what they're being provided by the seller, and that led to redundant evaluations being done, which is a waste of money because both parties are paying for the same thing. And so by putting the requirement for this on the buyer, we think that will ultimately remove some of the costs associated with these transactions that's been ongoing. Those are the big points, and that's a lot. And I'm going to pause here and see if people have questions. And I do have some details and things to get into after this, but I wanted to see if there are any questions or comments on these bigger issues.
Susan,
yes, go ahead,
ahead.
My question is this. In the past, as you've said, we had a septic designer who was doing the assessments. Now you're talking about an evaluator. What is the difference in what they do to determine the health of the system?
So good question. So first off, the designer, when doing the site assessments, was not looking at the actual system. They were looking at the lot, so to speak, like how many acres it is, what types of soils are on the lot. They would do a desktop survey to say, is there, what are your plans for a septic system? But they weren't out there pulling the covers on the tanks or using cameras and things to look at the septic system itself and see if it's, all the connections are the way they should be, or if there's any obvious failure. They would if there was some very obvious failure, like you go out and there's breakout on the surface, they would identify that, but they weren't doing more invasive things. Evaluators, on the other hand, their whole function is to look through the whole system and do a more thorough review of the system as it is. They aren't looking at the lot. right? They aren't looking at the soils and things, so it's a very different function. And the discussions we had on this bill was that at this point in where we are in the state with the development on our lakes, what we really need is for people to be looking more carefully at the systems that exist than to be looking at the lot and the soils, because if someone is really going to like rebuild, right, if they're going to tear down the house and they're going to build a 8-bedroom house, they'll have to work with a septic system designer who's going to advise them whether or not that is possible. And so the site assessment seemed a bit redundant in that case.
Okay, so to follow that up, we're actually talking about a septic inspection, which most buyers do have when they purchase a property, correct?
Yes. Yep. That was one of the points, is that buyers were already getting this done. And so why not make this the requirement as opposed to something that most people weren't needing?
Okay, so the difference then would be what happens with that paperwork once the inspection is done.
Mhm.
Correct?
Correct.
Because right now it just goes to the buyer and then the buyer determines what they want to do.
Mhm.
But this so-called assessment now would go to the state, to DES?
Only if the evaluator determines that the system is in failure.
Okay,
You know,
all right.
yeah. So this is between the parties. They can negotiate how they would be doing currently, but if the system is deemed to be in failure, then there would be a notification required to the state and to the local health officer.
And that would come from the evaluator.
Correct.
Okay,
Yep.
thank you.
Yeah. And then
Great
so the notification to us is to kind of get us aware that there's a failed system. We get a lot of notifications of failed systems, regardless of real estate transactions, and we keep track of those to make sure they're getting done. And so we would just keep track of it and wait to see a follow-up report from the buyer within 180 days saying, yes, I've repaired the system. We kind of match those two up and close the file.
Thank you.
One question that I have is not every septic designer is an evaluator and vice versa. I'm assuming that's correct.
That's
Yeah.
correct.
And from an evaluator's standpoint, where would one go to find out who is actually authorized to do that? I know we have septic inspections today, but I find a lot of the times the septic inspections are done by some of our septic companies. And are they all evaluators technically?
Right. Their evaluators are licensed by the state. They're done through the Joint Board of Licensure. So there's to know if someone is an actual licensed evaluator, you can ask for their license number and their license, right? So I think going to one of these companies like you have been and saying, I need a licensed evaluator, is how you would find them. There may also be a list, and this is something I'll look up so that I have this information for a future outreach on this, is, there may be a way to look that up through the joint board. But I think essentially to make sure you're working with someone who's got the proper credentials, you just need to ask for their license as a septic system evaluator.
Okay, yeah, and there probably is, Phil, if they do have to have a license in the state and it's through, the joint board OPLC, you can do a license lookup, right? And so I could look up estheticians in the state of New Hampshire if I wanted to. And I only use that word because my wife happens to have that license. But okay, great. Anybody else have any questions at this moment before we let Phil to get into some other details? If you do, just kind of open up your mic and scream something out. If not, we're going to let Phil go on and see what other questions we can come up with. All right, not seeing any at the moment. Phil, why don't you keep going?
Okay, so just a couple of details. We made a few other changes to the law that I think are good. One of which is we changed the definition of developed waterfront. In the old law, it had said, developed waterfront was basically some sort of lot that was within the 200-foot buffer of the shoreland or the shoreline. Of course, many of you are familiar that we have the protected shoreland regulation, which uses a 250-foot buffer. And having the 200-foot buffer versus a 250-foot buffer was endlessly confusing for people. So we matched those two up, and we're just going to basically use the 250-foot set, buffer for the developed shoreline. We also, more importantly, changed the applicability of the requirement for this site assessment. The wording of the the law previously had been a little bit vague. It talked about lots that touch this 200-foot buffer, and so you could have a case where somebody might have a very big lot, and it stretches all the way down to the 200-foot buffer, but their house and septic system is much farther away than the lake. It could be 500 feet away. Now we've clarified this to say, okay, we're only going to require this site assessment when you're dealing with, a septic system or a component of a septic system that's within that 250-foot buffer. All right. So in that previous example I gave, they would not be required to do this site assessment because the septic system is outside the buffer. Another detail is that all the wording in the bill is related to property transfer as opposed to property sale, because sometimes properties change hands without a sale, and so it's related. So if you have a case where there's a transfer, I guess even between family members, this requirement would still be in effect. And then lastly, and this is something I covered during Susan's question, which is that the notification requirements. Most of these evaluations are not going to come to the state. If it's just in something that says, hey, your system seems okay or might need some work in a few years, we're not going to see that. That's just between the buyer and the seller and the negotiations that they would do normally. But if it is found to be in failure or showing signs of failure, notification of the state and the local health officer will be required. And that would come to us. Like I said before, we would kind of keep that on a list of to make sure that there's follow through. And we'd expect that 99% of the time we're going to get a report from the buyer within 180 days saying, yep, we replaced the system and we're all set. And if not, we would have to follow up, as we would with any other report of a failed system that hasn't been repaired. All right, those are the details. Any questions on those?
So I have a question.
Yeah. Yes. Go ahead.
So the 180-day requirement notification is the time period to commence upon the receipt of the failure or upon closing?
It's upon the transfer date. Yeah, so the way the sequence is supposed to work is that the evaluation is done before the transfer date, and then all parties know what they're dealing with. There's time for negotiation regarding price and things, and then the 180 days to fix a system if it's deemed in failure would start on the transfer date.
And so,
and then there is that opportunity for extensions as needed.
As a follow-up question to that, so the buyers are now doing the site assessments, but let's, for argumentative sake, say the buyer gets the assessment, it fails, they've decided not to purchase the house. The notification still has to go to the state, but now who notifies the seller that the 180-day clock is starting, or does it not start because the transfer hasn't happened?
It's a good question. And this is one of the reasons why I'm glad we're doing these, because I want to make sure we square that up. I think the notification only goes to the state upon the transfer. So if the sale falls through, there would not be a notification. So
you could potentially have these failed systems out there that the state doesn't know about because the transfer didn't happen.
Yep. And they're there now. so it's not like it would be a new thing. And hopefully through this bill, we're catching them and getting as many of them cleaned up as we can. I will check on that issue, but I believe the way that we've written this is that it's just based on the transfer. So if the closing falls through, then no notification would be provided.
The only notification then would be potentially the seller's disclosure to the next future buyer.
Correct. Yep.
So I just want
to. A good one.
Yeah, no, that's a great question, Gidget. Thank you. So I just want for everybody to understand this, how I take it, that I take a listing and it's on Lake Sunapee, which I actually put on my picture today, just because we're talking about waterfront. And the system is within that 250 feet buffer, right? I take the listing. My seller now does not, well, once this becomes official, I guess, does not have to do a site assessment. It's on the buyers to do that site assessment. Is that correct?
That's correct.
Okay. So this is law. So the buyers will be required to do this. It's not an option.
Mm-hmm. Yes, they'll be required to do it, and they're required to do it prior to the transfer date. So some people might say, "Oh, I'll buy it now, and we'll do the evaluation and figure out something out later." The requirement is that it's done prior to the transfer date, so that there's
right. And I guess the kind of point that I was getting at in the climate that we're in right now, with multiple offers and all this craziness that's been going on, I could see some buyer that might say, well, I'll make an offer to these people, but I don't want to do any inspections or any of these, septic evaluations. Here's my cash offer, for more than asking, using that as a potential tool to try to get the sale, before other people. However, now, as we're being told, this is going to be law. So buyers, no matter whether they want to do this or not, they're going to have to do it by law prior to transfer of title.
Ben, you're generally correct. There's a couple of things that may some further details, I guess. One thing is that there's a provision that allows the seller to, or the buyer to accept a previous evaluation if it was done within 180 days. And that could have been done by the seller, right? The seller could have one done and say, I've done this within 180 days. You can accept this if you'd like. You don't have to do your own one. So that's an option. We thought of there might be these scenarios where, one sale falls through and, someone has already done the evaluation and why do it again, just, a month later. So there's that option. So a seller could do their own and then, say that the buyer could accept that if they wanted to. And then there is this other provision, which is dealing with a tear down situation where if a buyer says, look, I'm going to raise this property. I'm rebuilding an entire house. I'm going to get a designer. We're going to put in a whole new septic system. I don't need to evaluate the existing system. They can do that as well. And, basically they would notify, that would be notification to the state that says, this is a tear down situation, you'll be receiving a new septic system design within 180 days. So those are two other ways in which they might not have to do it.
Okay, so that makes a little more sense to me now. So a seller could have an evaluation done should they want, kind of like a seller could do home inspections today prior to listing their house if they wanted to. Not every seller does that, but they could. And that seller could say to the buyer, hey, if you want to use this evaluation, you can, as long as it's within, that 180-day period. But I think the point, Phil, that I'm getting from all this is let's say the buyer has the evaluation done, everything goes great. We come to the closing table, and for some other reason, financing or what have you, the deal falls through. And that evaluation was paid for by the buyer. The buyer doesn't necessarily have to pass that on to anybody else. And the seller would not have access to that. Is that correct?
That's correct. Yeah.
Okay. All right. All right. So now, other people may have some questions, but I have a few more. And I know we usually try to do a hard stop at 9:30, but if this runs over, that's fine. I'm assuming there's going to be changes to forms and or some of your own internal rules and regulations and things like that we may see. When might some of that stuff take place, and how do we find that information out, and how do we find out what forms are going to be used now?
Yeah. And these are all the questions we are asking ourselves. The governor just signed this bill last week, and so we now know that it goes into effect within 60 days when 60 days after he signed it, which is September 1st, 2024. We're working on the rules for this, but the rule process for us takes normally 6 months, and so clearly the rules are not, and the forms are not going to be ready by September 1st. When you have a situation like this where there's a law that differs from the rule, the law wins basically. So during this period when there isn't rule, you should follow the law, and it will be published as RSA 45-A:39. And we actually don't need any forms for this for the state, because the notifications are pretty simple. They're just, we just need to be notified of a failed system. And that can just be done in any, in writing in any way that's convenient. Email, a letter, that kind of thing. Eventually we may get a form. I think we probably will, but it's not too complicated, because what we'd expect is we'd get a letter or an email that said, here is the this at this property the system was determined to be in failure. See attached evaluation. Some sort of report from the evaluator. And that hopefully should be, we're hoping that that will be sufficient for the period of time until we have rule, and then we'll have some rule that will flesh things out. We've already got some questions that people have given us that we have to sort out in rule, like what if it's a shared system? Like let's say it's a condo situation and there's a shared system for multiple properties, and then one of those properties is sold. What if it's deemed in failure? Who has to pay? Like that kind of thing. And so we'll be sorting that stuff out in rule. Our default assumption on that is that that the bylaws of the association would govern kind of how costs are shared among multiple owners. So if someone who buys a condo is now the buyer, and the system's determined failure, like do they have to pay entirely to replace the system? I don't think so. It'd probably be cost shared associated with all of the owners of the property. But we would need to spell that out in rule, because we know some of those situations will come up.
What about, Phil, what about the evaluators? How are they, and roughly, do you know how many there are in New Hampshire, and how are they being notified of all these changes?
Evaluators, I don't know how many there are. And as you mentioned, there's a lot of people who are designers and evaluators. So there's a lot of the same people that you'll be working with, but they'll just be using a different license for this work. There's an evaluators board, and we're going to be doing some outreach with them in this summer also, to make sure they're aware of the changes and prepared for those changes before September 1st.
Great. Any other questions from anybody? We have the expert here, so let's ask away. And one thing that I will say is Phil is going to be going on and doing a podcast at NHAR that will be sent out to all of the realtors in the state of New Hampshire. And I kind of got to him first, so this is kind of the trial run. So I'm really appreciative that, yes, Susan, hang on one second. I'm really appreciative that Phil was willing to jump on with us. And so us here at Caldwell Banker Lifestyles are hearing this information firsthand from a guy that's in the trenches with all of this. So we can't thank him enough. Susan, your question, go right ahead.
Yeah, quick question. So between now and I think you said September 1st, it's status quo as far as what we do?
Correct.
All right, so if a buyer right now does not want a septic inspection because they want to beat out everybody else on an offer, they don't have to have it. Is that correct?
That's correct. Yes. Yeah.
Okay. Thank you.
This
Okay.
bill will not take effect until September 1. And I did put I posted a link to the bill text that was finally signed by the governor. It's a chaptered law in the chat. It's kind of got a short name because that's just the way it came out of, the general court website. Hopefully that link will work for people so you can read it. It's not that long. It's about 2 pages. And I'd like to think it's fairly clear. But, one thing I've learned about legislation is, you go into it thinking, oh yeah, all we need to do is this. And then there's always another thing, and there's something is particular, and then someone wants to make an amendment later, and then things get a little bit wonky. It's a challenging thing, and it was a real pleasure to work with the New Hampshire Association of Realtors on this bill. They're real professionals, and we're very helpful, and I think we came up with some good language.
Yeah, great. Thank you. Any other questions of Phil before we let him go? Phil, thanks again for having us on. Once we get this recorded, all taken care of, I'll send you that link so you can share it on your end, wherever you want to do. And, I'd love to have you back on maybe after September, once this kind of gets a few months under our belt. We'll see what's happening and any kind of the bumps in the road that we might want to talk about after. But thanks very much for coming on. We're super, super happy. Stefan, did you have a question?
No, just wanted to say thank you very much. Appreciate it. That was great information.
Yeah. Well, it's our pleasure, and we'd love to be back. There's a lot more issues that we could talk about. And I know septic systems is not like what everyone really looks for when they're buying real estate, but as I like to say, with real estate, geology is destiny. Right. Your well and your septic system is governs a lot of what you can do with your property. And it's really important that people understand that. And, we'd be happy to do more with you all on related to that topic.
Great.
Thank you, Phil.
I'll make sure to send this bill out to all of our agents as well. Phil, thanks again very much. And we'll touch base after we get this recording all squared away so you can send it out. And you and I will be in touch soon. And thank you very much. I look forward to seeing you on the podcast.
Thank
all right.
you.
Thank you, everyone. Have a
Thank
great day.
you.
Thanks, guys.
Thanks,
Thank you,
Ben.
everyone, for logging on. Take care.